Defenses to negligence. We have two that we're going to discuss: assumption of risk and comparative negligence. These are the two basic ones. These defenses are based on the idea that everyone has a duty to exercise reasonable care for his or her own safety. Persons who fail to exercise such care should not be able to recover because their own behavior helped cause those injuries. So, for example, if Craig, who is texting on his cell phone and walking, steps into the pathway of Andy's speeding car without checking to see whether any cars are coming, his negligence will not necessarily fully prevent him from recovering damages, but he may be limited in covering because of his own conduct of not paying attention while he tried to cross the road. He was walking and using his cell phone. Assumption of risk. This is voluntarily assuming the risk of injury from a danger. Put this into context. Skiers, if they go to a ski resort and they buy a pass, generally it's written on that pass somewhere, small print usually, or on your receipt. It says that you assume the risk of injury due to skiing. Skiing can be dangerous, especially if you're trying it out for the first time and you think you're going to go very high up on the mountain. But nonetheless, you assume that risk. It is a dangerous thing to do and engage in. And if you take chances or risks or go too fast and you ski and you hit a tree and you're injured, or you fall down and you get an injury, you're assuming that risk. There's nobody you're going to be able to sue. But some locations, some ski resorts actually make their own snow. And they use snow guns to do that if you're not familiar with skiing. To make more snow or to get snow on the trail, they actually have machines or snow guns that they make snow with. So let's say you're a skier, you go, you buy a pass, you know the rules, you're assuming the risk of skiing, but as you're skiing down this one trail, you make a turn and you collide with a snow gun that's sticking out of the middle of the snowbank that nobody took out. Did you assume that risk? Did you assume that, hey, if I go skiing, I might run into a snow gun in the middle of the trail? The answer is probably not. That may not relieve you. You may have not assumed that risk, and if you are injured, you may have a cause of action for negligence here. Remember, you just go through the steps: duty, breach, harm, causation. Another example of assuming the risk: if you get into a vehicle with a driver that is obviously drunk and there is an accident and you are injured, you assume that risk. The key is that the plaintiff must fully understand the nature and extent of the risk to be held to have assumed it. There's knowledge of the risk and there's voluntary assuming as such. A driver entering a car race knows there's a risk of being injured in a crash. Hockey players, football players, rugby players, any contact sport, you're assuming the risk. Comparative negligence. This is liability for injuries based on a proportionate share of negligence. This distributes the cost of the accident according to the degree of both plaintiff and the defendant's fault. Remember my individual who stepped off the curb, Craig, who stepped off the curb into Andy's pathway. We'll talk a little bit more about that in a second, but how about the McDonald's case that I introduced in the torts overview video, where the woman sued McDonald's after spilling hot coffee on herself and suffering burns. Ultimately, the court in the end found her 20% at fault and 80% to McDonald's and reduced the award accordingly. Most states use what we call the quote-unquote pure form of comparative negligence. This allows a plaintiff to recover even if her fault is greater than the defendant's, and others have a 50-50 rule where the plaintiff's fault was, if the plaintiff's fault was 50% or more, they get nothing. So the pure form rule, plaintiffs can recover even if they're at a greater fault. So if the plaintiff was 80% and defendant was 20%, and that's how it's going to be. Any award will be divided in that way. And if it's more than 50% plaintiff in other states, you're not going to get any. So assume that a jury determined that Craig in our first example, was 33% at fault for his injuries because he wasn't looking when he crossed the street, he was texting. And Andy was 67 because he was speeding. That Craig suffered, and then we'll say that the jury awarded 27, or said that Craig suffered $27,000 in damages. What would happen was Craig would get 18%, which would be 67%. That's what he would get from Andy. That's how that distribution would be made. Brian is an experienced ATV rider. Without putting on a helmet, Brian takes his ATV for a ride. It flips, and Brian strikes his head, sustaining injuries. He files a suit against the ATV's manufacturer. During the trial, it is proven that Brian's failure to wear a helmet was responsible for essentially all of his injuries, which cost $100,000. And Brian's state has the 50% rule. If the manufacturer is found 10% liable, what will Brian collect? And I hope you're saying nothing, because that's the case in the 50% rule kind of state. If plaintiff's fault was 50% or more, they get nothing. Strict liability. This is liability regardless of somebody's fault. A person who participates in certain kinds of activities is held responsible for any resulting harm to others despite the use of the utmost care and caution. The idea behind this is that the risks associated with certain activities should be borne by the person whose actions created the risk and caused the loss, rather than by an innocent person who has suffered the loss. So generally, these kinds of activities are saved for those that we call naturally dangerous or ultra hazardous. And it doesn't matter how much care has been taken. If somebody is engaging in something that is ultra hazardous or naturally dangerous, they're going to be responsible. Newman Mining Corp is using dynamite to create a new nickel mine located in an Idaho wilderness area. Despite the company's reasonable care in storing the dynamite, a vandal sets fire to its on-site storage facility, and the dynamite explodes. The subsequent explosion damages nearby homes and acres of harvestable timber. Newman responsible, even though there was no fault there? The answer is yes. It's liable because of the inherent danger, the dangerous nature of using dynamite in its operation. That's going to be a strict liability. Joe operates a tiger rehabilitation center on his property. He takes reasonable care that all fences and gates are secure. After a windstorm, a gate becomes loose and a tiger pushes its way out and escapes, attacking an individual jogging by the property. Is he liable, Joe? Yes, because that is an inherently dangerous activity he is engaging in. Despite any sort of care that he's taking, if a tiger gets out, there's a dangerous situation. Products liability law involves defective products or wrongful death due to a defective product. Also includes breach of warranties of products. These are types of torts which are discussed in the contracts section. Need to know a little bit more about sale of goods before we can get here and have a thorough discussion. But products liability is a form of strict liability. The product is found defective when it's left to plant, company is strictly liable. Environmental laws are also strict liability. An oil spill, dumping in navigable waters. All of those actions, doesn't matter if you're negligent or intentional, there's no state of mind required in here. Going to be strictly liable. Going to be strictly liable under some consumer protection laws as well. So next up, let's talk about damages. Someone who is injured or harmed, they want to be compensated. But how does a judge or a jury calculate damages? Money can never undo pain or undo a permanent injury, but the only thing a court can give is money. So what does a successful plaintiff receive? Well, commonly they receive compensatory damages, and this is the actual damages suffered. The amount of money that a court believes would restore the plaintiff in a position he or she was in before the defendant's conduct that caused the injury. But what does it consist of? Some examples: proven medical bills, physical or mental. It includes past and any future expenses. It includes lost wages, court takes in the number of days missed for work and multiplies it by the number of the salary, and basically does calculations. And if that person is going to be out of work, continues to be out of work, there'll have to be expert testimony that attests to it, because these are the things that are actually proven damages. That'll be calculated too. And then the court will take into account pain and suffering. And these awards vary based on the suffering. There could be a traumatic experience. There's still fear. They suffer from nightmares. There's still some sort of psychological pain. At what kind of level? How old is the person that, and how much longer they have to live? And takes into effect whether they'll continue to experience pain and suffering. So things that can be proven, and generally it's medical bills, lost wages, and pain and suffering. And then we have punitive damages, and these damages are intended to punish the defendant for conduct that is extreme and outrageous. It is awarded in few cases. There has to be really extreme and outrageous conduct. The idea behind these damages is that certain behavior is so unacceptable that society must make an example of it. A large award would send a message to others from doing that kind of conduct, and it prevents the defendant, hopefully, from repeating that mistake. But what has to be shown is the defendant acted in a blatant, malicious, gross, reckless kind of manner. The U.S. Supreme Court has ruled, though, that these awards have to be reasonable. The McDonald's case, there was punitive damages that were awarded. The jury set out $2.7 million. Their calculation was based on how much McDonald's made in 2 days just on coffee. The court found that unreasonable and reduced that award. Which courts do. They'll review a jury's determination to make sure that they're reasonable. An appellate court, which is a higher level court from the lower court, will review both of these damages, compensatory damages and the punitive damages. When they're looking at the compensatory damages, they're going to review that record from below and to determine whether or not there was abuse in creating the calculation and was the proper calculation properly conducted. They're looking at what happened below. But in punitive damages, they're not only just looking at that review, they actually look at it as what we say de novo. They get the party who is claiming that the punitive damages was unreasonable or excessive, they can ask for a review right from the court. So it's kind of like a little mini hearing. Generally, appellate courts will not review new information or hear it, but in this instance they do hear it. They call it de novo review. Also, on the other side of that, though, they also look for inadequacy, so the other party can come in and argue that the punitive damages wasn't enough. So most of the time this issue of punitive damages gets settled. That's what happened in the McDonald's case. That's what happened in the Ford Pinto case that I discussed in the tort overview case. So the courts will review for excessive or inadequate. They can amend it, and they can determine whether the correct amount was reached. And there was an intentional tort case from last year involving Alex Jones. It was an intentional tort case of defamation where the family members of the Sandy Hook victims sued Alex Jones. And there was a case that started in Texas with one of the victims, and $1.1 million in compensatory damages was issued, but $45.2 million in punitive damages was awarded, and the court upheld both of those and did not change it. And then at the tail end of last year, there was a Connecticut case that was pending with 15 families against Alex Jones, and a jury awarded $965 million in compensatory damages and $473 million in punitive damages, and that amount was upheld. So with those two cases, he was close to $1 billion is what he had to pay out two individuals in an intentional tort case of defamation. There's still one more case pending in Texas. But the crux of that case, if you're not familiar with it, was Alex Jones. He's kind of a conspiracy theorist individual, and either on his talk show or his podcast and radio show. He's got a radio show. He's very much, as people would describe, a right-wing radio host. And he would make claims over and over again that the shooting that took place in the elementary school in Newton, Connecticut was staged. It was a staged government plot to take guns from Americans, and that, quote unquote, no one died. He called the parents of the victims crisis actors and argued that some of them never existed. So that was repeated over and over and over again. And families testified, and the FBI agents who investigated testified. But anyway, nonetheless, big award in an intentional tort case.